Good afternoon. I'm Ted Williams, Fox News. You all have said that the
Listen, folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you? All right. Who's responsible here?
What's that?
Who's responsible here? Whose house is this?
Yeah. Haven't been drinking or anything, right?
No.
Okay. Drive careful, okay?
Will do, thank you.
This is with the other group that ran away.
Oh, really? You just ditched it? Awesome.
Yeah, those ones kept walking in the car. And the other one.
It's truly for the win.
That I was given to. So there was 2 different discs. Hello and what is up, guys? Welcome to the Transparency. This is scheduled to start, I believe, at 4 p.m., which is Eastern Standard Time, 1 p.m. in Moscow. So again, welcome to the Transparency. Started this a little early, that way people could get the notifications. You guys could tune in, and I can add to the stage the recap. This is a recap that I put together. It's been a minute. But here it is.
Good afternoon. I'm Ted Williams, Fox News. You all have said that these killings are targeted. Can you share with us why you believe they are targeted killings? And do you know who, if any, of the victims were the actual targets of the killings? Why you believe they are targeted killings? And do you know who, if any, of the victims were the actual targets of the killings? Why you believe they are targeted killings? And do you know who, if any, of the victims were the actual targets of the killings?
We stated earlier in the previous press release, our press conference, we believe they're targeted because we take a totality of all the circumstances that we're looking at. Do we know any one person that it was targeted? We're not able to say at this point in time due to our investigation, but we still believe that. But we, like I said, we take a totality of everything that we're looking at.
Let me just take you back to Sunday morning about 1:45. At that time, all 4 victims are back in this house. Now, there are 2 entrances to this home. One through that front door that has a coded lock. We've learned that at times that coded lock would be left off because a lot of people would come to this location for parties. And then there's a sliding back door. And Lawrence, there were 2 individuals in this home that or was left untouched. Somebody the next day, around 9 hours after this incident was supposed to have taken place, called law enforcement. When law enforcement got here, they found that the door was unlocked. There was no forced entry. But, Lawrence, I can further tell you, at some stage there was an autopsy performed. The medical examiner said that there was blood all over this place, all on the walls, on the floors. It was a very vicious attack, and the weapon that the medical examiner said was a knife.
The names of the 4 University of Idaho students killed at an off-campus home over the weekend. Moscow police say 20-year-old Ethan Chapin of Conway, Washington, 21-year-old Madison Mogan of Coeur d'Alene, 20-year-old Xana Kernodle of Avondale, Arizona, and 21-year-old Kaylee Goncalves of Rathdrum, Idaho, were found dead yesterday around noon local time in Moscow. Moscow police said the 4 found are homicide victims. The University of Idaho has canceled classes today out of respect for the students.
We understand the public's frustration about not being provided a lot of information. We are working to the best of our ability to actually provide as much as possible. We intend to come out and solicit information from the public if they are within certain areas that we believe are of interest for this investigation.
Why you believe they are targeted killings, and do you know who, if any, of the victims were the actual targets of the killings?
We understand the public's frustration about not being provided a lot of information. We are working to the best of our ability to actually provide as much as possible. We intend to come out and solicit information.
Don't mind that typo that never got fixed. Blame me. We don't have autocorrect here. All right. What is good, guys? Welcome to the transparency. Today there is a hearing. There's 2. Well, there was 2. One should be kind of came to a close. Yeah, buddy. Oh, wait. I want you to tell that joke that you told me yesterday. What joke did you tell me yesterday? It was good. It was a good one.
I already told him that.
It was about the something about moo.
Yeah, but I already did that one.
Oh, you did? I don't think I shared it. I didn't get to share it though. So can you tell me one more time?
Too bad. Nope.
Too bad, so sad?
Come on, Mom.
Oh, you guys missed out on the joke. All right, hang tight there. All right, back at it. Ramen noodles come first. Nobody lost sound. We're all good here. Let's see what we got here. 3:46, so this is supposed to start at 4. We'll see. Judge is going to use his channel for the first time, his YouTube channel. Can you guys believe it? Uh-oh. There is no mainstream media in the courtroom, remember? This is the first hearing. So they had the first one earlier. So right here, it's 4 Eastern in Moscow. Well, technically it's 3:46. So there it is, 12:46 at 1 o'clock. That's when the second part is supposed to start. That's the part that they're opening to the public. That's the part that's supposed to be streaming off of his YouTube channel. This is the first time. They're also going to make it public for us to hear the conference, the status conference update with what's going on with the scheduling of the case. I'm going to go ahead and put a case management schedule together, which ultimately would reveal when the trial date would come. So we'll see if that's going to happen. What they're having a hearing about, remember, this is to talk about, should this indictment be tossed? Should it stay? Sealed, unsealed. What else we got? Also, I think there's going to probably be a little bit of discovery talks because 12th, I believe it was the 12th request. So I'm sure that'll slide in there a little bit. Once they start talking about, we're talking about a case management briefing with the scheduling. But we don't even have discovery. When are we going to get some discovery? Well, guess what? Once you get this management schedule, it's going to have deadlines for stuff, and that's kind of what you want. So what time is the live hearing today? The live hearing today is in 12 minutes, according to Moscow. It's supposed to start at 4 p.m., which is one there. There was one earlier that was at 10. So this is the second part. The 10 o'clock was not streamed. It was private. Again, so this is the second of 2 hearings. The first one was at 10 a.m. That was not open to the public. Even if you were in Moscow, you couldn't attend it, okay? So, but again, I will be simply streaming Judge's YouTube channel, which is how everybody now, if you want to watch anything to do with this case, you're going to get it straight off of his YouTube channel. And then that's how mainstream media would stream it. That's how, I would stream it. That's how anybody would stream it. But this is their first go round with doing it this way. So Judge, everybody has to go this route to get the information, which is the live stream. Truth and Trans lesson is broad stream. I mean, if people want to broad stream me, smile. Oh God. So I'm excited to hear. I'm excited to hear some of the oral arguments in regards to the grand jury stuff. But more importantly, I want to hear the case schedule. I want to hear, okay, when are you going to lay down that, boom, here we go. This is when we're planning on a trial. And then all the dates leading up to that trial date, which is, when you have to have your expert witnesses in, when you have to switch, here's our deadline for discovery. Here's our deadline for X, Y, and Z. So, but so here we go. Again, welcome everybody to the Transparency. You're here for a reason. Idaho4, you guys have been following it if you've been following this channel from the beginning. Bryan Kohberger arrested 7 weeks after the murders. And they say that they did it off of surveillance cameras that linked them to a white Hyundai Elantra, as well as a sheath that had his DNA on it. The defense is arguing that that sheath was planted and that you guys used IgG, a method, a tool as far as investigative, but they didn't want to turn over, the state did not want to turn over anything to do with how they went about determining that the DNA on that sheath was Bryan Kohberger's, because when they put it through CODIS, no hits were, came back. Obviously, Bryan Kohberger doesn't have a history, so his DNA is not in the system. But they were able to then, what they say, and they try to keep hidden, was how they went about using IgG to determine that that DNA then, in fact, by testing his father's garbage, came back that that was the biological father of Bryan Kohberger. And therefore, that's what put our all eyes on Bryan Kohberger. Well, Judge made a order and said that, hey, you're going to have to turn over. He did not say, nope, the defense doesn't get anything. Nope, the defense is getting this investigative tool / discovery, which it should be. We're going to go ahead and turn it over after having an in-camera hearing, and then meeting with whoever Judge met with to determine what he should then deem discovery and that work product, and then that's not going to be turned over. So that happened. When was that? They had to have that in December 1st. I think he made that decision when he ordered on it at the beginning of January. So let's see where we're at here. Judge. I don't know who's running his YouTube page. I don't know who is behind it. Right now, when you look at it, there is nothing up that says there's a live broadcast scheduled or anything like that. So that's interesting. Judge's channel jumped from having 5.7 subscribers just a day or two ago to now he has close to 16,000. Curious if they're going to monetize the channel. So he was gifted a community page. He has not used his community page yet. He has not used his channel, period. So I'm just curious who's going to be running his YouTube channel. Man, always giving 100. Oh, thank you. Nobody can find Judge's channel, but it is out there. It's available. We are looking at 7 minutes roughly before we start. A lot of people are streaming this from Judge's channel. Again, this is the only way that there is no cameras in the courtroom besides his YouTube channel. So the mainstream media isn't in there. It's not like they're, everybody has to go this route. That doesn't mean that people can't be in there right now reporting and standing outside saying we're live from the courthouse, but nobody got a bid to actually be the public media provider. That Judge claimed that that's how he was going to run his courtroom because people weren't following instructions on not zooming in on Bryan Kohberger, and they want to have transparency, and they thought the best way to do that was to take over the cameras, which I'm fine with because at the end of the day, I don't give a shit who's in there. I just want the camera in there, right? So you're also allowed to have your laptop in there now. You can have your phones and stuff. You just can't take any photographs. You can't record. So people could be there from whatever agency, whatever media outlet. They just can't record. This is the only way that they can stream anything is through this YouTube channel. So again, welcome to Truth and Transparency. Appreciate you being here. 5 minutes and counting, says Debop. Well, it is 5 minutes. I'll go back to showing right here them, but
on the walls, on the floors. It was a very vicious attack, and the weapon
right there, when you see the
on the walls, on the floors. It was a very vicious.
right there from Sigma Chi standing right across the street, seeing the house right there. The house is no longer standing, obviously, but let's take a look. Right now, Judge again has nothing up. He is now to 16.3K subscribers. I'll put notifications on too now. No live. Let's see if a live is scheduled yet. Nope. So I wonder if they're going to claim some technical difficulties in doing it the first time. I don't know. 161 waiting on his channel. There ain't no 161 waiting. In order to see that, you have to see that there's a live scheduled. So I don't know where that's at. I'm on his channel. That's interesting right there. They should have done a test live. I know they should. Well, actually, you don't really have to do a test live. But you could just do one for like members or something and test it out. But who knows? I'm sure he's got it all handled, right? I said to use the university and let the kids in the media department get credit for it, and in terms of a like an intern type ship thing. But whoop, whoop, Judge done a test on Wednesday. I don't know. He took a pregnancy test. No, guys, come on now. The first hearing may be going longer. Nah. They have to have their lunch break, you guys. Come on now. But yeah, 2 minutes until it's like allegedly supposed to start. But again, once it does start, boom, we'll take over. They did a live the other day. See, there you go. Good. No, why would I put the judges? Sorry, Tara. No, I can't promote. Sorry, Tara. I don't promote other people's channels. Tara, bless your heart. I just thought I'd go ahead and answer that once and for all. Lana, someone is streaming off of you. They must be pretty cool then. The best is when I get people like Annie Potts saying, gosh, I'm at work. I would so appreciate it if you could let me know up-to-date stuff. I said, sure, between me running my channel, I got Annie Potts, gonna send her some text messages. We got it. Let's take a look. Do. 16.6K subs now. People are just patiently waiting for Judge John Judge to drop his link. Annie, they just tossed the case out. Should we fuck with her? Annie Potts. You're never going to believe this. Annie, you're never going to believe this. They just tossed the decision. I thank you guys for being here. Hopefully you're here because you want to be in such a great chat with people that are like-minded individuals like yourselves. Again, all opinions are always welcome as long as they're respectful. Boop, boop. Judge. What a name. What are the odds that a person will become a judge with the name Judge? So. Ooh. Court never starts on time. You're damn right there, Lori. Only when it starts on time is when you don't need to start on time. It's kind of like planes, right? When you're there early, plane gets delayed. When you're running late, the plane's never delayed. When you're trying to catch a connection flight, you know, and you're like, oh, shit. You know. Again, today, what we're talking about, or what they're going to be talking about is, they're talking about the indictment. They're talking about the grand jury. They're going to be oral arguing things that should be sealed, not sealed. Why they want it tossed off of jury instructions. Remember the jury, the way that the jury was instructed. And I want to hear more about how the jury was instructed, right? That's just, think about that. Think about anything you do in life. You need proper instructions to properly do what you're going to be asked to do. So think about you go to take your SATs and they give you the wrong instructions and then you fail the test because they, you know, so the instructions matter. So I'm curious on all that. Just because I love you, Lana. Kim, thank you very much. All right, Judge is up to, let's see, 16.8K subscribers. Judge John Judge. 16.8. Again, hello to everybody. I finally made it today. Someone please catch me up. Well, there's nothing to be caught up on. This is a live hearing that we are waiting for. We are waiting to say when they want to go live with their hearing. Oh, thank you. Oh, thank you. So again, if you're here today, you are here because you are ready to witness the Idaho4 Bryan Kohberger is back in the courtroom. Today's January 26, 2024. He had 2 hearings, the first of which was blocked to the public. It didn't matter if you were in Moscow, you could not get through that door. It was closed. The second hearing, which was scheduled for, 1 Moscow time, 4 p.m. right here, Eastern Standard Time. And that is what we're waiting for. And then they're supposed to have a case scheduling, and that was supposed to be also public. That's what I want. And what a case scheduling is to, if you're going to go ahead and you're going to name, this is the date where we're having this trial, and then all the dates that come before that date are the dates like when last day that here discovery, expert witnesses, disclose those. We're going to have a hearing. This is the last date to do like anything to do with suppression hearing. Let's see what else. Anything that you could think that comes along with deadlines in a case. That's your case scheduling. So those of you guys have been following the Delphi case before all the shit show that happened with Judge Gall. So what that would mean is that today we would find out a date when the trial would start. I want that for the families. I want that for the families. I think that'll just hear when's the trial supposed to start. So that's what we should be hopefully privy to today. Again, you just never know though. Judge John Judge is up to 16.9K subscribers, and nothing is live yet. So we're at 4:06. We're at 1:06 p.m. Again, we are waiting patiently for this man. All rise. Court is now in session. So, are you going to be commenting what's going on? I think that it'll be self-explanatory what's going on. Once the hearing starts, you really want to focus on what's being said. I'll be breaking it down afterwards. I don't think it's going to be a super long hearing. We haven't had any super long hearings. But I really want to hear them oral argue this. I want to know what these jury instructions were, and why they believe that it should be tossed, meaning the grand jury indicting Bryan Kohberger should be tossed. I thought it was good, really good news. I thought it was the right decision that the investigative genealogy, all of that stuff should be turned over to the defense. So when people want to say like, oh, Bryan Kohberger is winning mini trials, or he's these little wins. No, guys, this is just our rights being upheld. How about stop saying that Bryan Kohberger won anything? Okay. Doesn't matter who would be in this position. I hope to God, if it was you, you'd want all the information as to why you were accusing me. Why are you saying that I did this? And how you think that you could ever withhold anything like that? All of us as United States citizens should be pissed to say that you think that you could ever do that. So these aren't little wins in the courtroom. Okay. This is our rights, and our rights should be upheld. Again, we got the tick, 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 tick. Judge, where are you? Latah County, Idaho. I want people who hold the justice system accountable, says Meatball. Yep, absolutely has to be done right. Yep, due process. This is a huge part of their case, and anybody that would say that it's not is absolutely lying to themselves and their loved ones. So, exactly, says the Richard. Innocent until proven guilty. All day, every day. That's how it goes. Tara, absolutely. We shouldn't have to beg for stuff. Like, I don't even think that they should have been arguing. If I was Bill Thompson, I'm not arguing why we shouldn't turn this over. Why? What do we have to hide? Turn it over. But the moment that you feel that you don't have to turn something like that over is the moment that I think everybody in the world, once you hear that, should wonder why you wouldn't want to turn something like that over. That's just fucking a joke. Why would you think that one of the biggest things as to why you are saying this man did something, which is the sheath and the DNA on the sheath, but we're not going to talk about anything that came from that. Get the fuck out of here. I'm sorry, but that's just, don't even get me started. Kohberger pimpin'. Yep, Kohberger pimpin'. Mary Lopez says the due process this year has been poorly handled, in my opinion. These are our rights. Absolutely. If they can do this to anyone, they can do it to you. That's how I feel. And I think more and more people, hopefully, you're going to start feeling that way, because some people maybe they don't grasp it, but if this was your life or your loved one, you'd feel differently. And I think it says a lot that when the Gonzalez's come out and say that they want transparency, put the shit out there, put it all out there. And hey, we may be dragged through the mud, but guess what? Like, we're prepared for that. We know that could happen. but be transparent. Here we go. We got something. Whoa. We got it. Let's go ahead and share it.
Necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you have all seen the amended order governing courthouse and courtroom conduct. We made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can go to the Supreme Court, I guess, website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. I think that's all the preliminary. Is Ms. Taylor?
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
Your Honor, I'm gonna, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye?
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address. It is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Mr. Nye. Mr. Logston? Reply.
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank
you. Excuse me. Well, first of all,
you're trying to kill someone.
This is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there is not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Nye said.
I agree with that.
That's significantly more delay. So there's some other, actually, this is in a case law, Idaho versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson? No, sir. Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Logston said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this courtroom. We would ask that that not be allowed any further. Now, as to the trial, Ms. Niner already noted that we have a variety of competing interests here. We have
Those are
certainly
fighting
the
words,
defendant's
Bill.
right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events.
Your volleyball team's struggling, boy.
Consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
He's in charge of arguing the traffic.
Taylor?
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial. And the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order. And I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial.
Yeah, it is, B.
As everybody said today, a very complicated case. And I want to talk a little bit about what drives both
Fuck yeah,
our
bitch. Yes.
request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at two tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards, in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well, less than 10% of those witnesses.
Hell yeah.
In the mitigation
true.
phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain
Summer
what we
my
do with
ass.
mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present
6 weeks,
to
my
our jury
ass.
if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents
Call me in.
are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are
This is so
records
true.
yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We
Call
do
me up,
have
Ann.
several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares.
Give it here. I want the
In
discovery.
this case, we began asking for supplemental discovery in February of 2023.
Told you this was coming.
We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends, and then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained.
There's 19,000.
This isn't a new issue. I think the court's heard about this before. We've had bits and pieces of tips, and you know, they've come in and we've reviewed them. But the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor,
Humanize
summer
him.
of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June of 2024.
No fucking way.
Your Honor, I want
Amen,
to
Ann.
also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete.
Oh no!
We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. Okay. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well.
And Taylor be rocking that backseat right now.
One more question. So
sure.
I understand this. I mean, I'm aware
you don't understand
disclosures already.
She stays standing. I love it. You stay standing.
But do we need a whole nother year after this summer?
That's what the fuck you have to say?
Can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
I think she's in shock what he said. No, Your Honor, this week.
That's a tough question. If the state says you have everything and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a
Who do you
deadline
want
for
to go through all
discovery
this,
helps
Judge?
me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines and all of the materials will be in the state's hands so they can give them to you. And the records you need will be given to you when you ask. And the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario.
Oh.
I'm nervous telling you I'll be ready by summer of 2025. I'm nervous.
2025. The death penalty case,
This is
2025.
priority for everybody.
That's normal.
And, I want to be realistic.
You said that it's
about it.
complicated.
I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel.
Let them speak.
Let's go to Mr. Thompson and see what you have to say about all this. Just getting.
Yeah, Bill, what
getting
you got to say
things
now?
Ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge.
120
I
people you
think
had.
that's fair to say, and there's more information that continues to be developed. You know, it's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there, but
Most of which that are out there.
all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, and there won't be undue interruptions in the community that can cause issues.
She set the trap and they took
trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's going to change anything, Judge. When this case has national, if not international attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning.
He's trying to save it.
Friends in this community who have traveled to Mexico, and they say, people here were from Moscow.
Now they're scrambling to keep it. Now they're scrambling to keep the case.
It's not Moscow. It's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first, and not just rely on there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-location. Said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging, but I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Thank you, Mr. Thompson. So you're saying, looking at this realistically,
They both say
the amount of information, evidence, non-evidence, that's might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families.
I thought this was going to happen so quickly. Get the fuck up out of here.
Year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once.
Yeah, but what was the argument before?
It doesn't come back on appeal.
We can't send this to the Supreme Court because
or
why?
Subsequent things saying that
fucking get out of here.
Somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this.
You took a month to look over the DNA. You took a month.
March 2025, which Taylor, that would be a reach.
During March Madness, let's do it. Get the fuck out of here.
I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially,
they do this all the time.
Maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality.
The reality is what she just told you. That's the
I
reality.
know that there's lots of other issues to be addressed. I know there are going to be a lot of motions.
Yeah.
There'll be a lot of motions about the death penalty as well.
Yeah. So how is he?
So
She's giving herself and her client.
realizing to think that we have to have a case so far in the future.
Mm.
But if that's what is the right thing for everything to do it correctly,
Meatloaf.
we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal, and that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay, Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
Oh. Wow. I think the judge didn't even, I mean, he's like, he cut off Bill Thompson to be able to respond right after Ann Taylor's didn't even breathe speech. But she's absolutely right. She's absolutely right with all the stuff that she was speaking on, like how much stuff that is. They had 120 people on this case. Then you turn it over because you're doing this path, which she still says, you guys, she still says that this path, we still are unclear as to how you got to Bryan Kohberger. She said again, so people that are just saying that Ann Taylor is just saying this because that's her client, or she's, you guys, she keeps on, and then she, like, we need to rewind that and literally listen to everything that she's saying, because everything that she's saying is truth. Like, even though what you gave us and we're skimming through it, what you think that you have, I read, she said, I've been on this case for a year. What? And I'm over here like, that's what she said. I read their PCA, right? How are you getting to Bryan Kohberger? Even with what she's privy to plus the PCA. If people want to say Ann Taylor's just doing her job, she's oral arguing for her client. So you think she's lying up there? I don't. I've been screaming it from the rooftops. How'd you get to Bryan Kohberger? I've been screaming it from the rooftops that if you break it all down, document by document by document, how are you saying that the car on the 700 block of Indian Trails, Hills, whatever the fuck it's called, how are you saying that that's Bryan Kohberger's car? How are you connecting that dot to the WSU white, sedan? Are you kidding me? You're kidding me right now. No, you guys, you work the case backwards. You have a name and then make it fit, right? Make it fit. Well, that would be called premeditated, but it wouldn't be on the count of Bryan Kohberger, now would it? I think there's a reason that the Gonsalves are so adamant about this case being in the spotlight with transparency. There's a reason for it. They were the ones out there the whole time advocating so hard for their child, right? Like so pissed. Or was it emotion? Either way, I will tell you every single day that every single parent in this case, every single parent period that would ever go through what they went through, you're going to get a pass from me every single day with whatever the hell you do and whatever you say, because nobody knows how anybody would react. But you cannot take the fact away that Steve Gonsalves said, listen, we want transparency. We want truth and transparency. And he said it just like that. And I was like, oh, thanks, Steve. But he said it for a reason. And then he said, we are prepared to be drugged through whatever. We know that there's going to be stuff that comes out, but hey, that's just how it rolls, right? We want the truth. We want to know things. We're not going to let you sugarcoat shit to us. Okay. We want the truth. How Steve speaks on that is how I would speak on it for my kid. You're not going to, no. Lay it on me. I want it all, good, bad, and indifferent, because I want to make sure that y'all did your shit. Because if there's other people that were involved in my kid's demise, swear to God, if you're trying to save somebody, I'll break your ass off too. And the only thing that Jay Hodgson is arguing is, in my opinion, things that he has to do for his clients, right? But what Ann Taylor just did right there is she just broke it down that you guys want us to go to trial. Like, let me break this down for you. This isn't a 6-week trial. This is a 12 to 16 week trial. This is a 400 witness operation here. And we've been through 10%. Whoa. When we get things, it's in a complete disarray. I can only imagine. I want to see how they get it, but whatever. Woo. Woo, woo, woo. Judge, man. Do you want to know that? Are you ready for my joke yet? Can I say it before I get off?
I don't know the joke.
Yeah, you do.
Right, huh?
What's the one that you told me yesterday?
Yeah, but I already told him that.
No, they didn't hear it. The one with the moo.
Yeah, I know they did hear it.
They didn't. So can I hear it?
They did.
They did. Are you sure?
Yes.
Well, there's new people. These people aren't here all the time. Come on, you're my end all be all. Come on, you're my end all be all. What's the joke? Give me any joke then.
What is the cow's favorite subject?
What is the cow's
favorite subject?
What is a cow's favorite subject?
Yeah.
What is it?
The movies.
I love you. We're gonna go out of that. Yeah, the moo. Oh yeah. Look at that. All right, guys. Kiss and hug your loved ones. I'm telling you, Ann Taylor just brought it. So anybody thinks that Ann Taylor's in the back pocket of anybody up in Moscow, you all are crazy. You guys heard her say it. She said, we haven't even gotten to the point that we're going to put in to move this. And Judge went from being like, he went from being like he's speechless, but yet he's speechless, but says, hey, can we still get our trial in? Someone needs to, like, I don't know, talk to him. Maybe his colleagues should explain what truly is going on. But I don't even know. I don't even know what to say. Ann Taylor brought it, and anybody that thinks that Ann Taylor's bought and paid for, you're crazy. Woo. But I will tell you this, I went to check out their channel and that video is no longer available. So if you didn't live stream it, it doesn't just stay there. So let me show you guys something really quick. Right there. This video is unavailable. So if you didn't live stream that and have it recording on your you can't go and watch it. You're going to have to go and watch somebody else's feed in order to get the video. So I want you all to see that right there. As if you were to try to go to Judge's channel, you can't pull this up. That video is no longer there. So you're going to have to go and see somebody else's live feed who was streaming it in order to get the goods. And isn't that just wild? I think it's kind of cool though, because I think that's their way to be transparent in terms of this, that we're not taking any money over this. We're not, I don't have a YouTube channel to make money is what I think Judge is more or less like saying. And that the media, trust me, Lana, I recorded, it's on this stream. I have it recorded. But what I'm just trying to say is that if you do not record it in real time, if you try to go back and watch it, look at this. And that's what's interesting to me in a good way, and not a bad way, in a good way. And I think it's going to force you to go watch it from the media, not from a judge's YouTube channel. So all they're trying to control is the cameras. And I think that that's important. They were just trying to control the cameras, that we're not going to be zooming in on anybody, right? We're live streaming the proceeding. And that's all I want. I don't want to see anybody's zits. I want to just hear the material. I want the material. Okay. So this is a very, very positive thing right here. So do not take it as, oh my God, they're not being, oh my God, they deleted it. No. I think this is really, really good. Okay. They're letting the media handle the media aspect of it. We're just making sure that nobody is exploited during the process of it. Okay. So I want everybody to not run with some wild shit with what I'm saying. This is very, very good. And guys, I need everybody to know this. I am not on Bryan Kohberger's side. Okay, I'm not. I'm on the side of truth. Because if you did not hear it from me before, when is the last time that anybody has ever been swooped in, hey, you're the killer, and that was acquitted in a situation, and that they've ever went back out there, as in the police, to then go find the true perpetrator, to then try them for the case that somebody was acquitted in? Meaning that if we don't get this right the first time, nobody is going to be tried for this case. And people out there think that people may have messed up this for a reason so that nobody would ever be tried, and that there is true justice for those 4 victims, right? Well, we can't allow that to happen either. I'm not going to let that happen. So as much as you think that I'm going to, people think like, oh, Bryan Kohberger, Lana, you just went. No. I'm going to make sure that if Bryan Kohberger isn't the guy, that we're not letting Moscow, we are not letting the people that investigated this off the fucking hook. Like every other time somebody is acquitted. Okay? Every time somebody is acquitted, nobody does any work after the fact. They just say the jury got it wrong. Fuck you, man. So that's not going to happen either. But that's truly what happens every freaking case, that anytime somebody is acquitted, nobody goes out there and does work afterwards. So yeah, in a sense, if you don't get the right person the first time, then there is never justice if it is an acquittal. And that's just, God, that's scary. Why? Because people are too proud to say they messed up. Why can't they ever just blame it on the fact that people lied to you, man? These witnesses lied to you. That's why you got the wrong person. Blame them. Blame the truth on why you didn't get the right person. So, and all that I can say is that I will know that my heart, brain's motive, that it's always going to be in the right place, period. So I love when people say, shut up and let it play out. Well, why are you still here listening? Nobody's forcing you to be here. That's when you know that they just snort, Lana. So this is about our rights. This is about transparency. This is about 4 people's lives that were taken. And if I was a parent of one of those kids, There's no way in fucking hell I'm letting you feed me a book of lies and for me to go and blame some kid that didn't do it. If he did it, you fucking show it, and you show it with everything. And why do I have this fucking defense attorney coming at me saying she's not getting shit, that she's over here like, yeah, she's going to need time to go through this. You guys had 120 people times 7 weeks, okay? Do the math on that shit and how many hours, man hours went into that shit. Ann Taylor brought it, period. And I don't think it's going to be played out in Moscow, Idaho. And if he only wants to do this once, he should just look at it like, holy shit, this is going to be taken from me. That's what's about to happen. And it should be taken from him, because if it's not, it shouldn't be about the judge. It shouldn't be like, I want to overlook, I really want to preside over this because of what? No, as a judge, you should be like, yeah, it shouldn't be here because there's no way he's going to get a fair trial here. But he's over there white as a ghost because God forbid this doesn't happen in his town. Fuck you. And Bill Thompson, Ann Taylor walked you right into the trap of life. And that's why she had Jay oral argue first and what they were talking about. And then you have Bill Nye, the science guy, get up. And you guys were talking about the victims deserve to have this done so quickly. And da-da-da-da-da-da-da. And then she hits you with the 1-2 punch. Come on. Kudos to Ann Taylor. Ann Taylor owned that hearing. And anybody that says anything else, that's propaganda. Peace. Okay. They all knew about it.
Talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you? Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains, and like if you need a lot of brains, you're gonna be in trouble.
In trouble.